Hello, it's Dr. Beth Colby from Talk Mental Health. So what's the process of how somebody becomes detained under the Mental Health Act? Well, usually it's somebody they know, such as a family member, a general practitioner, psychiatrist, who recognises that they're very unwell, may need to go into hospital against their wishes, and a Mental Health Act assessment is arranged. Now, the person will be assessed by 3 different people, not necessarily at the same time. Ideally, it would be good if all the 3 people were there, so it would only be one assessment and less distressing for the patient. And the 3 people who are involved in the assessment are as follows. One is what we call the AMHP, Approved Mental Health Practitioner. And this is usually a social worker, although it could be a senior nurse, a psychologist or an occupational therapist. Patient's GP. And the third one is usually a psychiatrist, but it's somebody who's got certified as having expertise in the treatment or assessment of mental disorders. The 2 doctors, if they feel that the person does need to be detained in hospital, will fill in their forms, the recommendations, and then the social worker will do the application to a hospital for a bed for the person to be detained in. But then, okay, they've said they don't want to go to hospital, they've been sectioned, can you force them to go? Well, yes, legally, if somebody's under a section, then it is possible to force somebody to go to hospital. Usually people are taken in an ambulance, although sometimes police are asked to get involved to help enable a patient to get to hospital. And what involvement does the family have? Is the next of kin involved? Well, in the Mental Health Act, the term next of kin isn't used, but the term nearest relative is used, and it is defined term, so you can't just choose anybody. So a person is married, it will be their nearest relative will be their spouse or their civil partner. If they're not, then the next person would be their oldest child. If they don't have any children, it would be their oldest parent. If they don't have any living parents, their oldest sibling, and the list goes on until there is a legal nearest relative for somebody. The nearest relative have a couple of rights under the Mental Health Act. One is to oppose somebody being put on a Section 3 for treatment, and another one is to apply for them to be taken off their section. What about medication then? Can people be forced to have medication against their wishes? Under the legal framework of the Mental Health Act, people can be given medication against their wishes. If somebody's been admitted under a Section 2, which is up to 28 days for assessment of them, they can still be given medication as part of the assessment. And if they want to appeal against this section, they can apply to the managers, hospital managers, or for a mental health review tribunal within the first 14 days of the section. People detained under the Mental Health Act also have a right for an independent mental health advocate and for legal representation for the manager's hearing or the mental health review tribunal. If it's felt that somebody doesn't need to be on their Section 2 for up to 28 days, this can be stopped at any time. If somebody continues to be unwell and it's likely that they're going to need a longer period of time in hospital, then at any stage after the Section 2, a Section 3 could be applied for. And this is up to 6 months, and it's a treatment section. And this can be renewed, a Section 2 can't. So you could have a Section 3 for up to 6 months and another Section 3 for up to 6 months, and thereafter it's a year and a year for as long as it's necessary. If after the first 3 months of being under a Section 3, a person either has not got the capacity to consent to taking medication or is refusing to take medication, then a second opinion appointed doctor comes to see the patient to assess their capacity and whether this medication is to be given against the person's wishes. And every time somebody's put under a Section 3 or it's renewed, they've a right to a mental health review tribunal as well. What about time off the ward? Can people go home, go on leave? What happens? If it's felt that they're well enough, the responsible clinician can write what we call Section 17 leave for the patient to go out of the hospital for a defined period of time. And there may be certain stipulations as well. So it may be that they have to be escorted or it's to go to this particular place and for the length of time. So that's called Section 17 leave. So this can happen while people are on Section 2 or Section 3. So I hope that this has been useful and informative for you. Bye-bye.